Former Public Protector Advocate Busisiwe Mkhwebane's matter will be heard in the High Court in Pretoria today. She's seeking the court's urgent intervention in the Office of the Public Protector's decision not to pay her a multi-million rand gratuity due to her impeachment. Mkhwebane was removed, you might remember, from the Chapter 9 institution following a Section 194 inquiry into her fitness to hold office. Canny Maphanga on the story as always. She joins us now in studio for What to Expect. Great to see you. Thanks for popping by. The last time this matter actually sat earlier this week, we didn't even get to the merits because there was a back and forth around how the matter should have come to court. Take us through all of that.
Good morning, Ayanda, and to the viewers at home. On Tuesday, there were a couple of issues that needed to be ironed out, and usually those issues are ironed out before you actually come to the hearing. So the matter could not proceed on Tuesday. In any case, the Judge Collis, was going to allocate the matter to Thursday. However, she did want some assurance. We know that the applicants in the matter had to write a letter yesterday to confirm the issues that will be lineated on in today's hearing so that she knows exactly what she needs to adjudicate on. Remember, the main contention in Tuesday's hearing, the back and forth there was about where the matter should be heard. Right. Should it be in the urgent court, or should the applicants request a special allocation? The respondents seemed to think that there was an undertaking from the applicants that they would write a letter to the Deputy Judge President of the Gauteng High Court Division to request a special allocation. However, the applicants are stating that that is not the case, that they wanted to move forward with hearing the application in the urgent court. As we know today, we are in the urgent court, and we expect that they'll be presenting the exact issues, clearly defined, that need to be deliberated or adjudicated on today, and we expect that the matter will be heard.
Sure. There was also something about costs that was thrown into the mix.
Yes, the applicants are going to be seeking costs. However, the respondents are arguing that if you want to argue this in the urgent court, then the issue of costs is inextricably linked to that. So we'll see this morning if they've decided on a way forward. Should this matter be heard in a different court because of the kind of issues that need to be discussed, or will they continue in the urgent court? You may remember she's stating that because Parliament is coming to its end of term and we are going to elections, she won't be a member of Parliament anymore, at least until elections have been resolved, and that she would have lost significant income. So she's arguing that this is about her livelihood, and this is why this matter is urgent and needs to be heard and decided on immediately. Remember, she's asking for, if she's successful, that order to be made that she must be given that payment within 30 days.
Sure, yeah, I was about to ask you what the material difference actually is, depending in what court this is being heard in, but I suppose you've just explained it. Part of what Dalim Pofu, who's representing the Public Protector, former Public Protector, was arguing is that her livelihood is at stake, essentially.
But that's not the opinion of the Office of the Public Protector. They'll actually argue that the matter is not urgent and that livelihood and the end of your term as a Member of Parliament is not sufficient or compelling a reason enough for you to bring this in the urgent court. They'll also argue against this payment of the gratuity, arguing that it's actually a discretionary payment, not something that is given as a right.
Oh, wow.
I've had a peek at some of the arguments in the Office of the Public Protector, as well as Advocate Kolega Galega, the Public Protector now, the head of that office. Her answering affidavit, she's going to go into a lot of issues as to why these public funds cannot be paid out. She'll also highlight her responsibility to safeguard those public funds and not allow them to just be used any kind of way. She'll also go into many of those reports and the Section 194 and the costs that had on the Chapter 9. So you'll see the magnitude or the millions that she'll state was spent on that. And then, of course, she'll argue that, of course, the statutory requirement is that for you to get that payment, you would have had to vacate the office. We spoke about that on Tuesday, that she was removed in terms of Section 194, and an overwhelming vote, over 300 in favor of that motion. The President doesn't have any discretion in that. He carried out the resolution once it was communicated by the National Assembly. And we remember she was removed for misconduct and incompetence.
Correct.
That was the correct term. So because of that, they're saying that she does not have that right to claim that gratuity discretionary payment, and that the Office of the Public Protector will argue that all the money that is due to her has been paid.
Indeed, yeah, that's essentially the thrust of the argument, that we've already spent so much in the litigation, even if you're entitled to this money, it's gone already. But we'll see how the court feels about that. Canny Maphanga, great to see you as always. And of course, we'll catch up with you on the other side of today's hearing to get you a sense of how things unfold. Canny Maphanga, part of our team here at SABC News.